Greetings and salutations. Welcome back to another episode of the Legal Beagles. Wanted to give y'all a quick update on Kurt. Greetings and salutations. Welcome back to another episode of the Legal Beagles. Wanted to give y'all a update on Kurt. We tried to file the writ of habeas corpus yesterday. I called the court and they marked it as a miscellaneous file rather than a writ of habeas corpus. And it's my first live stream alone. So, yeah. So if the wig don't fit, you must have quit. But I wanted to give y'all a little bit of update. Let's see. Yesterday, they tried to tell us that we couldn't file a habeas corpus on someone else's account, and that's just not true. That's just not true. We go right up here. Let me find us. I'm sorry, I should have found this earlier. Oh, sorry. Bear with me, guys. I'm trying to find the code here. We posted. Yeah, so here it is. RCW 7.36.030. Petition. Contents. Application for the writ that shall be made by petition, signed and verified either by the plaintiff or by some person in his or her behalf, and shall specify: 1, by whom the petitioner restrained of his liberty, and the place where, naming the parties if known, and describing them if they are unknown, and 2, cause of pretense of the restraint according to the best of the knowledge and belief of the applicant, and 3, if the restraint be alleged to be illegal, and what the illegality consists. So absolutely, statute authorizing someone else to file on your behalf if you are unable to reach pen and paper like Kurt has been able to do. So they've filed it as a miscellaneous petition instead of a writ of habeas corpus. So the clerk is now involved on playing little shenanigans. I'm going to call them back here as soon as they open in the morning and try to rectify that. They could have approved our e-filing yesterday, but they ran out of time supposedly. So we'll see how that affects them moving forward. But just wanted to share that with y'all. And then one other thing that Tate wrote yesterday, he's going to try to appeal to the Ninth Circuit Court of Appeals for this writ of habeas corpus. And I read this last night, and, it was just so beautifully written and tells Kurt's story so well that I wanted to share it with you guys. And so this is Tate's writ, and I'm going to run through it real quick. It's not very long, but I, Tate Prowse, next friend of Kurt Benshoff, asked this honorable court to grant this writ of habeas corpus pursuant to 28 U.S.C. 2242 and 28 U.S.C. 2254. Prisoner Kurt Benshoff, home address, last known incarcerated King County, for charges within the Seattle Municipal Court. He's being held in King County Correctional. So, satisfied all the elements of the statute. He says, I ask this honorable court to take Kurt into federal custody so that he may be permitted the resources needed to defend himself. As of now, Kurt is being denied pen and paper, nullifying his ability to write a writ himself. The Seattle court system has proven itself to be a violator of basic constitutional rights, doing so under the misapplication of administrative law. Indeed, the Seattle Municipal Court system cannot conjure away basic due process rights in their administrative tribunals. This is from the Securities Exchange Commission versus Jarsky. In these family courts, Kurt properly argued that the court did not have statutory jurisdiction because Kurt was never married to his son's mother pursuant to the marriage as defined by RCW Chapter 2604, nor was Kurt ever in a domestic partnership under RC 2660-30, noting that at least one of the persons in a domestic partnership must be 62 years age or older. The Kangaroo Family Court ignored these valid arguments and proceeded without jurisdiction. The facts concerning Kurt's incarceration are labyrinthine. Summarizing as best possible, Kurt is a victim of the misapplication and maladministration of administrative law, which is what Chevron talks about, right? As well as the turning a blind eye by many judges. Kurt was essentially arrested for refusing to wear a face mask while shopping during the COVID-19 pandemic. This arrest of Kurt led to bitter and contentious legal battle within the administrative courts of Seattle. In these family courts, Kurt properly argued that the court did not have statutory jurisdiction, therefore depriving this Kangaroo Administrative Court of both subject matter jurisdiction and personal jurisdiction. As this Kangaroo Administrative Court sees itself a hammer and every citizen that steps foot within its doors a nail. Kurt was steamrolled and his valid arguments fell upon the deafest of ears. Kurt began filing lawsuits in both Washington state courts and federal courts, these lawsuits including every citizen and natural person that Kurt believed to have violated his parental and unalienable constitutional rights, including lawyers and judges. To say that feathers have been ruffled would be an understatement of the year. Kurt's actions gave rise to a comical display of judicial retaliation, culminating in trumped-up charges, restraining orders, and SWAT team home invasion. All these actions coming from Kangaroo Administrative Court that was then and is now bereft of subject matter jurisdiction and personal jurisdiction. It appears this Kangaroo Court and administrative law judge has set an astronomical bail of $750,000 for various trumped-up charges. The docket records for King County show the bail being absurdly high in the sum of $25,000 per case in reference to a nonviolent charge for allegedly violating 10 TROs, all TROs coming from Kangaroo Administrative Court with no jurisdiction, totaling $250,000. These bail numbers coming from a civil case over parenting rights. Kurt was arrested earlier this month after a SWAT team fired gas canisters through his windows, destroying Kurt's home. I, as well as many friends of Kurt, have made numerous petitions to the Kangaroo Court seeking the information, and the judge signed search warrant to no avail. There are very strange records now showing up on the Kangaroo Court website, showing that warrants were issued several days after Kurt's arrest, which could be precedent in some areas, but I guarantee they don't have all the elements they need, even if they produced them after. I believe the Kangaroo Court is doctoring and backfilling the record in an attempt to hide its outrageous lawlessness. Kurt has reported that he is not being permitted to access pen and paper, nullifying his ability to write his own habeas petition. Kurt is having his rights violated by the city of Seattle in nearly every way imaginable. And it appears no judge has the integrity to do a damn thing about it. Truly shameful displays of turning a blind eye to a citizen of the United States of America, a citizen with an unalienable, God-given rights that most certainly supersede the edicts of a Kangaroo Administrative Court. Reasons for not making application to the district court in the district in which Kurt is held. The Western District of Washington would be the venue in which the habeas petition would typically be filed. This cannot be done as the judges there seem to be just as corrupt and just as inept as the black robe right violators in the Kangaroo Administrative Court. Nor could this petition be brought into the Kangaroo Administrative Court as they have already proven incapable of following the most basic requirement of due process. namely ensuring the court has subject matter jurisdiction and personal jurisdiction over Kurt. These circumstances render such process ineffective in protecting Kurt's rights, as his rights clearly mean nothing to those administrating injustice within the Kangaroo Administrative Court. Kurt's friend and my good friend Benjamin Blanchard recently filed a habeas petition on his own. Benjamin filed his petition in the federal court in Tacoma in an effort to find fairness. However, that court assigned Judge Jamal Whitehead to rule on Benjamin's habeas petition. And this, it's not even marked a habeas petition. They marked it a miscellaneous because the court, we're unaware or unfamiliar that habeas can be filed by anyone but the petitioner, even though he has no pen and paper incarcerated in our jail. You know, it goes on. It goes on. However, the Honorable Judge, the absurdity of this decision cannot be overstated. The Honorable Judge Whitehead has already ruled against Kurt on several occasions, denying Kurt's pleas for injunctive relief from the malicious prosecution of the city of Seattle. These requests being denied, then lo and behold, Kurt had a SWAT team break out the windows of his home, administer tear gas in an effort to arrest him over exaggerated charges all stemming from a Kangaroo Administrative Court without any jurisdiction. These actions alone, not only ruling in Kurt's favor, would not disqualify These actions alone, not ruling in Kurt's favor, would not disqualify Judge Whitehead. However, the Honorable Whitehead, in one of Kurt's most recent federal lawsuits, administratively ordered the clerk not to issue summons to Kurt's complaint. The clerk is obligated to issue complaints when you file one. Obligated to issue summons if you file a complaint. And the court has administratively blocked this. The court clerk is required to issue permanently completed summons under FRCP 4B. These lawless administrative actions by the Honorable Whitehead led to Kurt filing 42 U.S.C. Section 1983 lawsuit against Whitehead in his individual capacity for the multitude of civil rights violations that Whitehead committed against Kurt. The law goes farther than requiring an impartial judge so as to satisfy due process right to fair trial. It also requires that the judge appear to be impartial. USC Constitution Amendment 14. A fair trial and a fair tribunal is basic requirement for due process. And they all know this. Fairness, of course, requires an absence of actual bias in the trial of cases. Such a stringent rule may sometimes bar trial judges who have no actual bias, who would do their very best to weigh the scales of injustice equally between contending parties, but to perform its high function in the best way. Justice must satisfy the appearance of justice. Recusal of judge for judges' alleged personal bias was not warranted by fact that in previous case, Court of Appeals reversed judge sanction order, but instead to preserve the appearance of justice in what had become a complicated and acrimonious case. The conclusion is, I do not know whether to laugh or cry when seeing the miscarriage of justice and wanton criminality in Seattle's courts. Perhaps the people of Seattle would have been better off with the Democratic People's Republic of Chaz. What has happened and continues to happen to my friend Kurt Benchoff is an abomination. Perhaps judges don't want to see their kangaroo administrative law courts in which they sit aloft and above the people come to an end. Many kangaroo judges see the administrative family court that they rule over as a cash cow. Perhaps it's as simple as many judges being just as dumb as the rest of the people. Well, we the people are awakening from our decades of long slumber, and we can clearly see that administrative law through administrative courts and procedures are misapplying statutes and violating people's inalienable rights under the color of law. This is exactly what has happened to Kurt Benchoff, and this honorable court should have him transferred to federal custody so that he can properly write his own defense with pen and paper. So I thought that was an excellent description of Kurt's situation, and I mean, as complicated as his issues are, Tate was able to boil them down into a nice, concise way that everyone can understand it. So I thought I would read that this morning. Wanted to remind everyone that it is at 8:30 in the morning, the Seattle hearing. It was originally posted at 1:30. I had 1:30 for a long time yesterday. I've changed it, so it's updated on that, and I will leave the new notes and description of how to get on the Zoom call in this in the comment section just when I'm done. So you'll have that, and so you'll be able to get on the Zoom call. It's at 8:30 a.m. Seattle time. So that's 10:30 Central Standard Time, 11:30 Eastern Standard Time, and I would imagine 9:30 Mountain Time. So the links to the Zoom call I will post immediately after this call. And just wanted to get this live stream out. I mean, these tyrants in Washington are getting me up before 7 o'clock in the morning now. Talk about standing for having, for having an injury. Anyway, I bid you all adieu, and let's all keep Kurt in our prayers today, and those Seattle judges and administrators over there, that they may administer justice fairly today. And so we will see what happens, and hopefully the federal court will intervene and get him in proper lockup where he can, write his own defense, because there's no better defense than Kurt. I can tell you right now. So I see a few people in the comments. I'm not going to drag this out any longer because I want everybody to be able to see it. But hopefully we'll get to those comments again soon. Signing off for the Legal Beagles.